Before last week's debate, I discussed the retained EU law Revocation and Reform Bill with Catherine Barnard, Professor of European and Employment Law at the University of Cambridge. What changes does the bill make?
The first, and by far the most dramatic, is it sunsets all of retained EU law. And sunset is the legal jargon for turning off all of secondary law which comes from the EU by the end of 2023. And this is really quite dramatic because it means turning off approximately 2,400 pieces of legislation. And suddenly to turn them all off would actually leave workers and consumers and other interested groups unprotected.
But they can be replaced.
They can be replaced, which is the second thing the bill does. It gives considerable powers to ministers to, for example, delay the turning off of retained EU law or to restate retained EU law as UK law, but in a way that's more suitable to the UK. Then the third thing that the bill does is to turn off the supremacy of EU law. Now, supremacy, as you know, means that if there's a conflict between EU law and pre-Brexit domestic law, EU law will still prevail.
Can you give me some examples of the sort of laws we're talking about?
Yes, they cover a whole range of issues: workers' rights, consumers' rights, matters concerning health and safety, quality of food. To give you a really concrete example, take the working time regulations, which sets a cap on the 48-hour working week, subject to some opt-outs, and also lays down 4 weeks paid annual leave. Now, with the sunset clause, assuming that the ministers do not use their powers to keep those rules, all of those provisions will disappear. So no 4 weeks paid annual leave anymore.
And what would replace it? I mean, if there's no law on annual leave, is it up to employers?
Absolutely it is, because prior to the Working Time Directive, the UK had remarkably little law laying down working time restrictions and certainly no national legislation on annual leave. And so if the law goes, so do those rules.
But the minister could decide to replace it with a UK law saying 4 weeks or 3 weeks or 5 weeks, up to the minister.
Yep, the minister has got the powers in the legislation to say, actually, we want to hang on to the working time regulations and all sorts of other workers' rights. But the interesting question, which is not resolved on the face of the bill, is what is the internal process for the minister to decide that they actually want to exercise these powers to keep those laws?
You presumably have civil servants in the department who would review them and advise the minister.
Absolutely, and that process is already underway. But if you've got a minister who's committed to deregulation, if that minister sits on his or her hands and does nothing prior to the 31st of December 2023, those laws disappear entirely.
And do you think that the departments, for example, DEFRA, which deals with farming regulations, have enough staff to review all the regulations that that department is responsible for?
This is one of the major concerns with this piece of legislation because, as you've indicated, civil servants have got to do a lot of sifting, and they've also got to decide which bits of law they want to propose to be kept and which ones could be got rid of. And DEFRA has the largest workload here, probably about 500 or so pieces of legislation. And it's thought that they only have about 3 full-time people working on it. And so the risk is that a lot of law just disappears with the sunset, even though actually it serves a valid social or environmental purpose. There is nothing to stop a sovereign parliament from turning off retained EU law, but to do it at a more measured pace when they've thought clearly about what they want to replace it with.
Professor Catherine Barnard.